And a New York jury has convicted the Trump Organization on 17 counts of criminal tax fraud and other financial crimes. Prosecutors say for 15 years, executives of the family business leaned on the company to evade income taxes on rent, private school tuition, and luxury cars. And it comes as several other investigations put mounting pressure on the former president.
There's one arena where Donald Trump's entire playbook falls apart. Not the campaign trail, where he controls the crowd. Not Truth Social, where he controls the message. Not Fox News, where he controls the framing. The one place where none of that works is a courtroom.
Senior investigative reporter Aaron Katersky joins me live now for more on this. Aaron, what was the evidence against the company here?
The conduct of its top executives, mainly Alan Weisselberg, the former finance chief who had served the Trump Organization for the better part of his life, even before former President Trump took over the company, worked for his father, and then some of the other executives who were arranging to be paid at least partially under the table.
Because a courtroom creates a permanent public record that no press conference can rewrite, no rally can overrule, and no social media post can erase. And when you line up every court outcome that has landed on Trump and his business empire over the past several years, what you're looking at isn't a series of isolated setbacks. It's a documented pattern of defeat that his political brand was specifically built to make impossible. Let me walk you through the full picture, because most people have lost track of just how much has accumulated. Start with the conviction of the Trump Organization, because it's the one that sets the tone for everything else. In December 2022, a Manhattan jury found the Trump Organization guilty on all 17 counts of criminal tax fraud and related financial crimes. Not a single count was dismissed. Not a single charge was found to be politically motivated by the jury that heard the evidence. The scheme ran for 15 years, from 2005 to 2021. Senior executives, most notably former CFO Alan Weisselberg, arranged to receive compensation under the table, including company-paid Manhattan apartments, private school tuition for their children, car payments, and cash. All of it structured to look like something other than taxable income. The jury didn't buy the argument that Weisselberg was operating alone without the knowledge or approval of upper management. They found the Trump Organization guilty as an entity, which under New York law means the conduct was acknowledged and tolerated at the highest levels of the company. The business that carries Donald Trump's name and that he presents as the foundation of his legacy is now, as a matter of law, a convicted criminal enterprise. That conviction hasn't been overturned. It survived the 2024 election. It survived Trump's return to office. It will survive his presidency. It is in the permanent record. Meanwhile, please leave your questions or comments in the comments section. I will answer each one individually as time permits. Also, I would be very happy if you liked the video and subscribe to my channel. Now, let's continue. Trump walked out of that courtroom and called it a rigged prosecution, a political attack, a witch hunt. The conviction didn't move. It's still there. And every legal proceeding that touches the Trump Organization or Trump's finances since then has that conviction sitting in the background as established fact. Then there's the New York civil fraud case, which adds an entirely separate layer. Judge Arthur Engoron found that Trump and his co-defendants committed persistent fraud by systematically manipulating the valuations of their assets across multiple properties over many years. The numbers are staggering in their brazenness. Mar-a-Lago was valued at anywhere from $18 million to $739 million, depending on whether the number was being used for tax purposes or loan applications. The triplex in Trump Tower was claimed to be nearly 3 times its actual size in financial documents. That's not a difference of opinion about valuation methodology. You cannot accidentally list a property at triple its actual square footage. That's a measurement. It can be verified with a tape measure. The financial documents doubled the real number. Engoron's determination was that this wasn't a one-time error or an aggressive but defensible accounting position. It was ongoing, systematic, and deliberate fraud spanning years and properties. He imposed significant financial penalties and business restrictions. Trump responded the way he always responds. He called the judge biased, called New York a hostile jurisdiction, and insisted everything would be reversed on appeal. The appeals process is ongoing, but appellate courts defer heavily to findings of fact made by trial judges who actually heard the evidence. Overturning a finding of persistent fraud requires proving clear error, which is an extremely high bar, especially when the trial judge documented the pattern in extensive detail. And then there's the Supreme Court, which delivered what may be the most consequential legal blow of all. In a 6-3 decision, Chief Justice John Roberts wrote the majority opinion ruling against Trump's emergency powers theory, the legal framework that was central to his second-term governing strategy. The court found that clear congressional authorization is required for the kind of executive action Trump had been taking, and that authorization doesn't exist. The tariffs he had implemented on that basis were ruled illegal. What makes this ruling particularly devastating is who delivered it. This is not a liberal court delivering a partisan rebuke. 3 of the 6 justices in the majority were appointed by Trump himself. Roberts, a George W. Bush appointee with conservative judicial instincts that generally favor executive authority, personally wrote the opinion. Chief justices choose who writes the majority opinion when they're in the majority. Roberts chose himself, ensuring that the language defining the limits of presidential emergency powers carried his institutional weight and would set precedent for future cases. This wasn't a casual brushback. It was a deliberate, carefully constructed ruling designed to bind future courts. Trump's response was revealing. His legal team called the defeat surprisingly sweeping. He publicly insisted it was limited and wouldn't affect his other emergency powers claims. He suggested he would find alternative legal paths to achieve the same policy goals. And then he said he would appeal the decision. You cannot appeal a Supreme Court ruling. The Supreme Court is the final appellate body in the American judicial system. There is no court above it. There is no further appeal available. His statement about appealing was legally meaningless, a performance for supporters who may not understand how the federal judiciary works. But the ruling itself is permanent, binding, and precedent-setting. It cannot be spun away. Now here's what makes the courtroom uniquely dangerous for Trump's political brand. His entire public persona is built around dominance. The image of a winner who never backs down, who always comes out on top, who controls every room he enters and every story that comes out of it. In media environments, that image is maintainable. He speaks first and loudest. He frames the narrative before anyone else can. He has cultivated a trust framework among his base that treats mainstream media and political opponents as inherently unreliable, which means his version of events always gets the first and most sympathetic hearing from the audience that matters most to him. Courtrooms don't work that way. A jury verdict is not a news cycle that can be managed. It's a legal outcome determined by 12 citizens under oath, evaluating evidence under rules that don't care about political affiliation. A judge's finding of fact is not an op-ed that can be countered with a stronger op-ed. It's an official judicial determination backed by the authority of the court and preserved in the public record permanently. A Supreme Court ruling is not a political opinion that can be shouted down at a rally. It's the final word from the body the Constitution designates as the ultimate authority on American law. The disconnect between what courts have found and what Trump claims publicly is the most revealing feature of this entire pattern. After every conviction, every adverse finding, every ruling against him, he walks out and declares victory or dismisses the outcome as rigged. And within the ecosystem he controls, that narrative holds. His base believes him. His media allies amplify the message. The story moves on to the next controversy. But the court records don't move on. They sit there, accumulating, each one adding weight to a documented history of legal accountability that exists entirely outside his control. A criminal conviction on 17 counts. A finding of persistent civil fraud across multiple properties and years. A Supreme Court ruling written by the Chief Justice with 3 Trump appointees in the majority, striking down the legal theory underpinning his governing strategy. Each of these outcomes went through full legal proceedings with evidence examined, arguments heard, and conclusions reached by judges and juries operating under the law. Each one produced a permanent record, and each one stands regardless of what Trump says about it afterward. The political implications of this accumulating record are significant and underappreciated. Every legal defeat adds to a body of documented findings that future prosecutors, future congressional investigators, and future historians will treat as established fact. The Trump Organization's criminal conviction doesn't expire when Trump leaves office. Engoron's fraud findings don't disappear if the appeal fails. The Supreme Court's emergency powers ruling will be cited in cases for decades. These outcomes are building an accountability architecture that exists independently of the current political environment and will outlast it. And this is happening at the worst possible time for a president who needs every ounce of political capital focused on managing a war, a fragile ceasefire, and an economy reeling from the highest inflation in 2 years. The legal walls are closing in from one direction, while the geopolitical crisis presses from another. The domestic political cost of the Iran war, approval at 36%, gas above $4, two-thirds of the public wanting it over, is compounding with the legal cost of a presidency that courts keep ruling against. Each court loss chips away at the foundation of the strongman image. Each failed legal argument undermines the claim of invincibility. And the audience watching these losses pile up isn't just Trump's political base. It's the international community, the military leadership being asked to execute his orders, the allies being asked to trust his judgment, and the adversaries calculating whether the man on the other side of the negotiating table actually controls what he claims to control. Trump's brand says he never loses. The court records say otherwise. And in the long run, court records outlast brands. They outlast presidencies. They outlast the news cycles that try to spin them away. The courtroom is the one place where the performance doesn't matter, where the spin has no legal weight, and where the permanent record tells the truth whether anyone in power wants it to or not. And right now, that record is getting longer with every case that reaches a conclusion.